In 2026, over 1 in 3 Canadian seniors could be at risk of losing their homes, not because they broke the law, but because the laws changed around them. Across Canada, new housing rules are quietly being introduced that could make it easier for landlords to evict, raise rent beyond affordability, and cut down protections seniors once relied on. For those living on fixed pensions, these changes aren't just inconvenient, they're potentially devastating. But what exactly are these new laws? And how could they suddenly force thousands of elderly Canadians to pack up and leave the homes they've lived in for years, sometimes decades? The truth is, most people won't even realize what's happening until it's too late. That's why you need to hear this now. In this video, we'll break down 10 new laws coming in 2026 that could directly impact seniors, including some that may already be in motion without you knowing. Number 1. Stricter eviction rules are coming. Across several provinces in Canada, 2026 is shaping up to be a turning point for tenant protections, and not in a good way. New legislation is being proposed that would tighten eviction timelines, broaden landlord powers, and reduce the window of time tenants have to respond to notices. For seniors, this shift is especially dangerous. Many are living month to month on fixed incomes, and even a short-term financial hiccup, like a delayed pension payment or unexpected medical cost, could now be enough to trigger legal eviction. What's more alarming is how subtle these changes can be. In Ontario, for example, eviction for non-payment of rent used to require a longer notice period. But under proposed revisions, that grace period could be reduced to as little as 7 days. That's barely enough time for anyone, let alone a senior dealing with health issues or limited access to legal support, to respond, pay up, or seek assistance. Similar moves are being considered in other provinces, including Alberta and British Columbia, where eviction hearings are being fast-tracked through virtual tribunals, often leaving tenants confused or uninformed about their rights. For many seniors, the home isn't just a roof. It's a lifetime of memories, security, and community. Losing it isn't just a housing issue, it's a mental health crisis in the making. These new laws may seem small on paper, but their real-life consequences are massive. If you're a senior or know someone who is, now is the time to understand your province's eviction rules. Reach out to local legal aid services, document your communications with landlords, and consider joining tenant advocacy groups. Because once an eviction notice arrives under the new system, the clock will be ticking faster than ever. Number 2. Shorter notice before eviction. One of the most concerning legal changes coming in 2026 is a reduction of notice periods for late rent payments. In the past, tenants were typically given 14 days to settle their arrears before an eviction process could begin. But new proposals in multiple provinces aim to cut that time down to just 7 days, or in some cases, even less. For seniors living on tight and often delayed incomes, this change could be the difference between staying housed and being forced out with nowhere to go. Imagine missing a rent payment because your pension deposit was delayed by a few days. Under the new rules, that's all it could take for a landlord to start eviction proceedings. And once those wheels are in motion, it becomes incredibly difficult to stop them. With less time to respond, fewer legal safeguards, and often limited access to support networks, many seniors may find themselves caught in a legal process they simply don't have the tools to fight. It's a harsh shift from a system that once offered protection to one that now seems to prioritize speed over fairness. This isn't just a minor adjustment. It fundamentally changes the balance of power between landlords and vulnerable tenants. Seniors often require more time to coordinate financial matters, communicate with housing services, or even just physically get to legal offices. Having the notice period doesn't just speed up evictions, it silences the chance for resolution. That's why it's so important for seniors and their families to act early. If you're falling behind on rent or facing financial stress, don't wait. Speak with your landlord, contact housing support services, and keep a written record of everything. When time is cut short, preparation becomes your greatest defense. Number 3. Rental blacklists for tenants. A deeply troubling development for 2026 is the expansion of rental blacklists, unofficial but widely used databases that track tenants who have had disputes, missed payments, or faced eviction. These lists are being adopted more aggressively by private landlords and property management companies, And in some provinces, there's talk of formalizing these records into public systems. For seniors, this could be devastating. A single dispute, even one where the tenant was not at fault, could leave a permanent mark that makes it nearly impossible to secure housing in the future. The biggest issue is the lack of transparency and regulation. In many cases, tenants don't even know they've been blacklisted until they're denied a rental with no explanation. Seniors who may have struggled with late rent due to health issues or administrative delays are especially vulnerable. These blacklists don't consider context, they just record outcomes. And with landlords increasingly relying on tenant screening services, even a minor blemish can effectively shut someone out of the rental market altogether. It creates a system where people are punished not just once, but continuously every time they try to find a place to live. What makes this more alarming is the difficulty in getting off these lists. There's rarely a clear appeal process, and landlords aren't obligated to update or remove entries. That's why it's critical for seniors to keep detailed records, every rent receipt, every written communication, every maintenance request. If you ever find yourself in a dispute, insist that everything be documented in writing. Don't rely on verbal agreements. And if you're applying for a new place and get rejected, ask whether a tenant screening service was used. Knowing what's in your file could be the first step toward fighting unfair blacklisting practices that threaten your housing future. Number 4. Less compensation for no-fault evictions. One of the quiet but powerful changes coming in 2026 is a reduction or removal of compensation for what's known as no-fault evictions. These are cases where tenants are asked to leave not because of any wrongdoing, but because the landlord wants to move in themselves, conduct major renovations, or sell the property. In many provinces, tenants were previously entitled to at least 1 month's rent as compensation in such situations. But some new policies are aiming to reduce that amount, or scrap it altogether, making it easier and cheaper for landlords to displace long-term tenants, including seniors. This change is particularly dangerous for older Canadians, many of whom have lived in their homes for years or even decades. Moving is not just an inconvenience, it's an emotional and physical strain. Seniors often depend on their local community, access to nearby health care, and familiarity with their surroundings. Being forced to move without sufficient time, money, or support can trigger a cascade of problems, from mental health struggles to increased risk of homelessness. And without meaningful compensation, many seniors will be unable to afford even the basic costs of relocation. It's important to understand that just because a landlord says they're moving in doesn't mean the eviction is lawful. In some provinces, this excuse has been misused, and without oversight, tenants are removed under false pretenses. That's why seniors should never accept an eviction notice at face value. You have the right to ask for proof and file a complaint if the notice seems suspicious. If you're being asked to leave for reasons outside your control, consult a legal clinic or tenant advocate immediately. The earlier you act, the better your chances of staying in your home or receiving the compensation you rightfully deserve. Number 5. Rent hikes tied to inflation. In 2026, several provinces are shifting how they calculate allowable rent increases, tying them directly to inflation rates rather than setting a fixed percentage. On the surface, this might sound fair. After all, if the cost of living goes up, landlords may argue that rents should too. But here's the problem. Inflation in Canada has been highly unstable in recent years, and when it spikes, so can rent, sometimes far beyond what seniors on fixed incomes can afford. This change removes the predictability that many tenants, especially older ones, rely on to budget and plan their lives. For seniors living off pensions, disability benefits, or modest retirement savings, even a small rent increase can have a major impact. But if inflation climbs 4%, 5%, or even higher, as it has in recent years, tenants could be hit with rent jumps that far exceed their income growth. What's worse, many landlords are allowed to stack these increases annually, which over time leads to an unsustainable rise in housing costs. While the idea is to balance the market, in practice, it places more risk and financial strain on tenants than it does on landlords. Seniors need to take a proactive role in understanding how this inflation-linked formula works in their province. Rent guidelines are often published at the start of each year. Check them and compare your new rent against the legal limit. If it goes beyond that, you may have the right to dispute it. Also, if your rent was recently raised above guideline, request documentation showing it was legally approved. Knowledge is your first line of defense, and staying informed could be the key to protecting your home from becoming unaffordable in a system that no longer guarantees stability. Before we dive into the next law, take a second to drop a comment. Have you or someone you know been affected by these changes? We read every story, and your voice might help someone else. And if you find value in what we do, hit that subscribe button. It's just one click, but it helps us keep bringing you the truth no one else is talking about. Number 6. National shifts in tenant protection laws. Across Canada, 2026 is bringing a wave of changes that could reshape tenant protections nationwide, and seniors may be among the hardest hit. While housing laws are mostly provincial, a growing trend is emerging from coast to coast, a push toward faster eviction processes, weakened rent control, and increased landlord discretion. These national shifts are not isolated to one city or province. They're part of a broader pattern where housing is being treated more like a market investment and less like a basic human need, a shift that leaves vulnerable populations, like seniors, at risk of being priced out or pushed out entirely. In provinces like Ontario, Alberta, and Nova Scotia, tenant laws are being revised to prioritize efficiency and flexibility in landlord-tenant relationships. But in reality, this often translates to shorter eviction timelines, reduced appeal options, and looser rules on rent evictions and personal use evictions. Even in provinces known for stronger renter protections, like British Columbia and Quebec, loopholes are being exploited. Meanwhile, federal policy continues to promote housing affordability as a goal, but many of the on-the-ground protections seniors rely on are being rolled back or watered down. For seniors already struggling with rising costs, this shift could quickly become a housing crisis. The most dangerous part? These changes aren't widely publicized. Many seniors won't know their rights have changed until they're facing eviction or a massive rent hike. That's why it's more important than ever to stay informed, read notices carefully, and consult local housing advocacy groups. Whether you live in a big city or a rural town, national policy trends are reshaping housing law from the top down. And if you're not paying attention, you may find yourself without the legal protections you thought you still had. Number 7. Emergency housing grants may not be enough. In response to growing housing insecurity, the Canadian government has introduced emergency housing grants, offering one-time payments, sometimes up to $2,000, to help tenants at risk of eviction. On paper, this sounds like a lifeline, especially for seniors on limited incomes. But in reality, these grants are often hard to access, come with strict eligibility rules, and may not be enough to make a lasting difference. The support is temporary, but the rent keeps rising every month. Many seniors are finding that by the time help arrives, if it does, they're already facing eviction or have fallen too far behind to recover. Another major issue is awareness and accessibility. A significant number of seniors don't even know these grants exist, and those who do often struggle with the complicated application processes, online forms, and verification requirements. For older Canadians who may not be tech-savvy or who lack support from family or caregivers, applying for these emergency funds can feel overwhelming. The system assumes a level of digital literacy and speed that many seniors simply can't meet, and that's if the grants haven't already run out due to high demand. The reality is, while emergency housing grants are a step in the right direction, they don't solve the deeper issue, the rising cost of housing and a shrinking safety net for tenants. Seniors need more than just one-time support. They need stable, long-term solutions that protect their right to age in place with dignity. If you or someone you know is struggling, reach out immediately to housing support services in your area. Don't wait until an eviction notice is at your door. Acting early is the only way to ensure you can access whatever limited help is still available in this fast-changing system. Number 8. Rent control loopholes are expanding. Across Canada, rent control was once seen as a vital protection, especially for seniors living on fixed incomes. But in 2026, more landlords are finding and using loopholes to bypass these controls, and in some provinces, the laws are being rewritten in ways that quietly weaken rent protections. One of the most common tactics is rent eviction, where a landlord claims they need to renovate a unit, evicts the tenant, and then relist the unit at a much higher price. While technically legal in many regions, it's often misused, and seniors are frequently the targets because they tend to stay longer and pay lower rents. In places like Ontario and British Columbia, certain units, especially those built after specific cutoff dates, are exempt from traditional rent control laws. That means landlord can raise the rent as much as they want once a tenant leaves. This creates a powerful incentive for landlords to push long-term tenants out, using any means necessary. Seniors who've lived in the same place for years and who benefit from older rental rates suddenly find themselves facing notices over renovations, family use claims, or minor infractions, anything to get them out so the rent can be reset. What's worse is that many tenants don't realize their units aren't protected under newer rent control exemptions. They assume they have legal backing when, in fact, they may not. That's why it's crucial for seniors to verify their rental unit status, understand the applicable rent laws in their province, and keep detailed records of all communication with landlords. If you receive a notice that seems suspicious, don't ignore it. Contact a legal clinic or housing support office immediately. In a system increasingly tilted toward landlords, knowing your rights is not optional, it's survival. Number 9. Rent caps vary wildly by province. One of the most confusing and dangerous aspects of renting in Canada right now is the lack of a consistent national rent cap. Instead, each province sets its own rules, and in 2026, those rules are shifting in very different directions. Some provinces, like Manitoba and Prince Edward Island, have introduced stricter rent caps to protect tenants. But others, including Alberta and parts of Atlantic Canada, have no formal rent control at all, allowing landlords to raise rents as high as the market allows once a lease ends. This creates an unpredictable environment where seniors are left guessing how much their rent might go up from year to year. This inconsistency is especially hard on seniors who have moved to more affordable regions in search of stability. A fixed pension doesn't stretch far when your rent suddenly increases by several $100s. And in provinces with no caps, landlords aren't even required to justify the increase. Even worse, some jurisdictions allow for above-guideline increases for things like building repairs, which tenants end up paying for without having any say in the matter. In places like Ontario, landlords can apply for these increases through the tribunal system, and many tenants don't even realize they can object or appeal. That's why it's critical for seniors and their families to research the rent control policies in their specific province or territory and not assume the protections are the same everywhere. If you're planning to move or renew a lease, ask your landlord whether your unit is subject to a cap and request that information in writing. The law can be complicated, but knowledge is power. The more you know about your province's rent rules, the better prepared you'll be to push back against unfair increases before it's too late. Number 10. Fewer protections against no-fault evictions. In 2026, one of the most unsettling trends across Canada is the erosion of protections against no-fault evictions, cases where tenants are asked to leave not because they've broken any rules, but because the landlord claims they need the unit for personal use, for a family member, or for major renovations. These types of evictions are becoming more common, and unfortunately, the laws meant to prevent abuse are getting weaker. For seniors, this is especially dangerous. Many have lived in the same home for decades and aren't prepared, financially or emotionally, to start over somewhere new. In the past, tenants could demand proof that a landlord was truly moving in or renovating, and they were often entitled to compensation or even the right to move back in after the work was done. But in many provinces, those requirements are now being relaxed or poorly enforced. Landlords can more easily make claims that go unchallenged, and in some cases, tenants are evicted only to see the unit re-rented at a much higher rate, a clear violation of the spirit of the law, but one that's rarely punished. Seniors often lack the legal knowledge or resources to fight back, and landlords know this. If you're a senior facing this type of eviction, it's critical that you don't just accept the notice at face value. Ask for everything in writing, keep records of all communications, and contact a tenant rights organization immediately. You may be able to challenge the eviction or demand legal compensation. These no-fault evictions are being used more and more as a tool to push out long-term tenants, and unless you know your rights, you could be next. Awareness and early action are the only ways to stand a chance in a system that's becoming harder and harder to navigate. As we've seen, 2026 is shaping up to be a year of serious challenges for renters across Canada, especially for seniors. From stricter eviction rules and shortened notice periods, to loopholes in rent control and weakened protections against no-fault evictions, the housing landscape is shifting fast and not in favor of those most vulnerable. For older Canadians who've spent years building stability, routine, and community in their homes, these legal changes threaten more than just their living space. They threaten their entire way of life. What makes this situation even more concerning is how quietly these changes are happening. Most of these laws aren't making headlines. Many tenants won't know what's changed until they're directly affected, until the rent spikes, until the notice appears, until they're told to leave. That's why awareness is your strongest protection. Knowing your rights, understanding the laws in your province, and acting early can make all the difference. Whether it's checking if your unit is rent-controlled, documenting landlord communications, or reaching out to a tenant support group, small steps taken today can prevent life-altering problems tomorrow. And remember, while the laws may change, you still have a voice. If these policies concern you, speak up. Contact your local representatives, share your story, and connect with others in your community. Seniors deserve to age with dignity, security, and peace, not under constant fear of eviction or financial strain. By staying informed and standing together, we can push back against systems that prioritize profit over people. Your home is more than just a building, it's your foundation. And protecting that foundation starts with understanding the laws that surround it. If this video opened your eyes or helped in any way, let us know in the comments. Tell us which law shocked you the most. We read every message, and your story could help someone else. And if you haven't already, please support us by subscribing. It's just one click, but it means everything to us. We put a lot of work into these videos to bring you the truth others don't talk about, so stick with us.